Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss general exceptions under Bharatiya Nyaya Sanhita 2023, Section 14 to Section 33.
So as you know, India's new criminal laws are here, but there's a huge mystery brewing. A fundamental golden rule from the old penal code seems to have just vanished. Today, we're putting on our detective hats to figure out where it went. Let's get right into it. All right, let me kick things off with a question for you. Imagine the prosecution proves every single element of a crime, let's say theft. Is a conviction a sure thing? Are the definitions of these offenses completely absolute? Well, you probably guessed it. The answer is a big, fat no. And understanding exactly why is your key to mastering criminal law. So, to really get what's happening with the new law, we've got to rewind the clock a bit and look at the foundation. This whole principle was laid out crystal clear in the old Indian Penal Code of 1860. You could call it the golden rule for understanding literally every single crime in the book. And this right here, this was the master key. Section 6 of the Indian Penal Code, 1860. Now, listen to the wording. It's so important. It says that every definition of a crime has to be understood subject to the exceptions found in the chapter on general exceptions. This one simple sentence was the bedrock that applied to the entire code. It was a universal rule. So what does all that legal jargon really mean? It's actually super simple. It means that every single offense comes with a built-in but. An act might look exactly like theft, but what if it falls under an exception? It might seem like someone is causing hurt, but what if they were defending themselves? Section 6 was the invisible thread that stitched the general exceptions from Chapter 4 into the very fabric of every offense. Okay, let's fast forward to today and the new law, the Bharatiya Nyaya Sanhita 2023. You open it up, you search for something like Section 6, and you find nothing. It's just gone. And that right there is the mystery that has so many people scratching their heads. And when you put the two acts side by side, the problem becomes really stark. The Indian Penal Code 1860 had this explicit, impossible-to-miss rule in Section 6. The Bharatiya Nyaya Sanhita 2023 doesn't. So this brings up the million-dollar question for every law student and professional out there. Has this core principle of criminal justice just been abandoned? Well, I'm here to tell you to relax, because the principle is very much alive and kicking. It hasn't been thrown out, it's just been integrated in a much, much smarter way. We just need to know where to look. So let's crack this code together. The solution is actually a pretty elegant two-step process. It's all about connecting the dots. First, you have to look very closely at the opening words of Section 2 of the Bharatiya Nyaya Sanhita 2023. Then, you just combine that with Chapter 3 of the same act, which, you guessed it, contains the general exceptions. And here it is, our first big clue. Section 2 of the BNS, which is the big definition section, kicks off with these 5 magic words, unless the context otherwise requires. This phrase is the new master key. It's telling us right from the start that no definition in this entire law is set in stone. It all depends on the context. So you're probably asking, okay, what is this context that Section 2 is talking about? Well, the context is Chapter 3 of the BNS, which covers Sections 14 all the way to 44. This chapter is the new home for all the general exceptions we know and love: private defense, accident, necessity, all of them. So by making every definition subject to context, the law is cleverly forcing us to read every offense with these exceptions in mind. It's the exact same result as the old Section 6, just done structurally. Okay, so that's the theory. But let's be real. For your exams, theory isn't enough. You need cold, hard evidence, and you need to back it up with case law. So let's look at how this all works in the real world. Let's use a classic, exam-friendly example. Person A intentionally injures person B. Now, on paper, that perfectly fits the definition of hurt under the BNS. But here's that context. What if A can show they were acting in private defense, which is a general exception in Chapter 3? Well, then the context changes everything. The result? A has committed no offense. It's a perfect illustration of the principle in action. And don't just take my word for it. The courts have backed this way of thinking for decades. In the landmark case of Tolerem Relumo versus the State of Bombay, the Supreme Court laid down a vital rule. If you can interpret a criminal law in two ways, you must choose the one that helps the accused person. And guess what? General exceptions are always an interpretation that favors the accused, so they have to be considered. This idea was reinforced again in State of Maharashtra versus Mohadi Yaqub. Here, the court was super clear that you can't just read a definition in a vacuum. You have to interpret it within the context of the entire law. This ruling is basically a perfect judicial stamp of approval on the BNS's new structural approach of connecting Section 2 to Chapter 3. Now, here's a pro tip for your mains exam answers, so listen up. What actually happens in court? The famous case of Dayabai Chugambai Tucker versus the State of Gujarat explains the procedure. It says that yes, the accused person has to prove they fall under an exception, but, and this is the crucial part, the standard of proof isn't beyond a reasonable doubt. It's a much lower bar called preponderance of probability, which basically just means more likely than not. Including this detail will seriously impress any examiner. So let's just summarize this whole shift with a simple table, and seriously, you should probably screenshot this for your revision notes. As you can see, the fundamental rule is exactly the same. All that's changed is the architecture. What was explicitly spelled out in Section 6 of the IPC is now cleverly built into the structure of the BNS through Section 2 and Chapter 3. It's a reorganization, not a repeal. All right, let's bring it all home. Think of these next few slides as your ultimate masterclass for absolutely nailing any question that comes your way on this topic. This is the final verdict. If you really want your answers to pop, you need to use these powerful legal maxims. They're like power-ups for your arguments. Actus non facit reum nisi mens sit rea. The act is not guilty unless the mind is guilty, is the soul of most exceptions. Then you have ignorati of facti excusat, which is all about mistake of fact, and necessitas non habet legem, which is the basis for the defense of necessity. Dropping these into your answers shows a much deeper level of understanding. Okay, pen and paper ready? If this topic comes up in your exam, here is the perfect gold standard answer. Though Section 6 of the IPC is not reproduced verbatim in the Bharatiya Nyaya Sanhita 2023, the principle that definitions are subject to general exceptions continues through Section 2's clause, unless the context otherwise requires, read harmoniously with Chapter 3. Therefore, every offense under the BNS must be interpreted in light of the general exceptions. Trust me, that phrasing is a guaranteed winner. तो याद रखिए, BNS में Section 6 जैसा कोई अलग section नहीं है, लेकिन doctrine जिंदा है, Section 2 और Chapter 3 के through. I really hope this explainer solved the big mystery for you. For more deep dives and to get crystal clear on the new laws, make sure you hit that subscribe button for Ganga Education.
So, here's the question for you. मान लीजिए एक पुलिस ऑफिसर गलती से किसी गलत इंसान को अरेस्ट कर लेता है, तो क्या उस ऑफिसर को सजा मिलेगी? This is a really critical question and it's based on a fundamental legal idea. Is every mistake a punishable crime? चलिए आज हम इसी कॉन्सेप्ट को डिटेल में ब्रेक डाउन करते हैं। देखिए, क्रिमिनल लॉ का मेन पर्पस है ऑफेंसेस को पनिश करना, बट इट्स ऑल्सो ट्रू कि हर गलत एक्ट के लिए सजा नहीं मिलती। क्रिमिनल लॉ सिर्फ एक्ट को नहीं देखता, इट लुक्स एट द इंटेंशन बिहाइंड इट, द मेंस रिया और द गिल्टी माइंड। हमारे नए क्रिमिनल लॉ द भारतीय न्याय संहिता 2023 के चैप्टर 3 में जनरल एक्सेप्शंस दिए गए हैं। बेसिकली ये ऐसी सिचुएशंस हैं जहां गिल्टी माइंड एब्सेंट होता है और इसलिए एक पर्सन क्रिमिनल लायबिलिटी से बच सकता है, और इन्हीं में से एक सबसे क्रूशियल डिफेंस है मिस्टेक ऑफ फैक्ट।
Okay, so let's dive right in. सबसे पहले we're going to discuss Section 14, जो ऐसी सिचुएशन से डील करता है जहां एक व्यक्ति बाउंड बाय लॉ है। In other words, वो कानून से बंधा हुआ है।
So here it is, Section 14 of the Bharatiya Nyaya Sanhita 2023. ये सेक्शन उस पर्सन को प्रोटेक्शन देता है जो कोई काम इसलिए कर रहा है क्योंकि कानून उससे वो करने के लिए मजबूर करता है, मतलब उस पर एक लीगल ड्यूटी है। And let me tell you, understanding this is absolutely essential for your judiciary exams.
Now the exact wording here is really interesting. Section 14 basically says कि कोई भी एक्ट ऑफेंस नहीं है अगर वो एक ऐसे पर्सन ने किया है जो या तो उसे करने के लिए लीगली बाउंड है या फिर, एंड दिस इज द इंपॉर्टेंट पार्ट, गुड फेथ में एक मिस्टेक ऑफ फैक्ट की वजह से ये मानता है कि वो बाउंड है। सो you've got three keywords here: mistake of fact, bound by law, and good faith. So what is this good faith? Simply put, it means acting with due care and attention. अगर आपने लापरवाही से काम किया तो सॉरी, ये डिफेंस आपके लिए नहीं है।
So in simple words, इसका मतलब है कि आप पर एक लीगल ऑब्लिगेशन है। You don't have a choice, आपको वो काम करना ही पड़ेगा।
और अगर आप इस लीगल ड्यूटी को पूरा करते हुए विद ड्यू केयर एंड अटेंशन कोई एक्ट करते हैं तो वो ऑफेंस नहीं माना जाएगा।
And this slide gives you the perfect example. Let's say there's a soldier and his superior officer gives him a lawful command to fire on an unruly mob. The soldier follows that order. Now, in this situation, the soldier has not committed any offense. Why? Because he was bound by law to obey the lawful command of his superior.
All right, let's move on and see how this concept builds. Section 14 के बाद अब हम आते हैं इसके काउंटरपार्ट पर, Section 17, जो justified by law की बात करता है। तो अब हम बात करेंगे Section 17 of the भारतीय न्याय संहिता 2023. Now, if Section 14 was all about legal compulsion, Section 17 is about legal permission or authority. Getting the difference between these two is so important for your exams. So Section 17 says कि कोई भी act offense नहीं है अगर वो एक ऐसे व्यक्ति ने किया है जो justified by law है. In other words, the law gives him the right or the authority to do that act. और यहाँ भी वही conditions apply होती हैं. It has to be a mistake of fact, not a mistake of law, and the act must be done in good faith. So what does this actually mean? Well, in Section 14, you had a duty, a compulsion. But in Section 17, the law is giving you authority or permission. The law is justifying your action. It's not placing an obligation on you.
Let's look at a classic example for this one. Let's say A sees Z doing something that looks like murder to him. Now, the law gives every citizen the power to apprehend a murderer. So A, in good faith, grabs Z. Later on, it turns out that Z was actually acting in self-defense. In this case, A has committed no offense because his action was based on a mistake of fact and was justified by law.
So, what's the real core difference here? This is the most crucial point to understand between these two sections. This is a gold star point for your exams because this is where most of the confusion happens, when to apply Section 14 and when to apply Section 17. Just take a close look at this table. Section 14 applies when a person is bound by law. This is a legal obligation, a compulsion. You have to do it. On the other hand, Section 17 applies when a person is justified by law. This is legal permission and authority. You can do it. Compulsion versus authority. That is the key difference.
All right, now let's discuss some points that are going to be directly useful for you in your exams. You should definitely make a note of these. First up, this legal maxim. Ignorantia facti excusat. Ignorantia juris non excusat. It simply means a mistake of fact can be excused, but a mistake of law cannot. You can't just say that you didn't know the law. This maxim is literally the backbone of both Section 14 and 17 because it's directly linked to the concept of a guilty mind.
Like we discussed earlier, good faith is an essential ingredient for this defense, and it means doing any act with due care and attention. If there's any carelessness or negligence in your act, you will not get the benefit of this defense. The court will always check if you took the necessary precautions that the situation demanded.
Now, if you get a question on this in your mains exam, you absolutely have to write these points. The court will check, was the mistake genuine? Was due care and attention taken? Was your belief reasonable? And finally, was your act proportionate to the situation? Including these points will make your answer so much more complete. And now for a very common prelims trap. You're often asked who has the burden to prove this defense. Remember, under Section 105 of the Evidence Act, the burden to prove this defense is on the accused, not on the prosecution. The accused has to prove that they acted under a mistake.
So, the key takeaway from this whole explainer is this. Section 14 is about compulsion when you are bound by law. Section 17 is about permission when the law justifies your action. And for both of these defenses to work, good faith is absolutely essential.
If you want to keep breaking down the legal concepts in this simple and clear format, then don't forget to subscribe to Ganga Education. Today, we're going to dive into a really fundamental question about our new criminal laws. What kind of protection does a judge have when they make a decision? We're going to find the answers in two very important sections, Section 15 and Section 16 of the Bharatiya Nyaya Sanhita 2023.
So, let's kick things off with a big question. One you might have even thought about yourself. Can a judge actually be prosecuted if a judgment turns out to be wrong? It's a really interesting thought, isn't it? And it gets right to the heart of what Sections 15 and 16 are all about. Okay, here's how we're going to break it all down for you. First, we'll talk about the main idea, what we call the judicial shield.
Then, we'll do a deep dive into Section 15, which protects judges, and then Section 16 for the officers carrying out orders. After that, we'll see how they compare to the old IPC sections, and finally, we'll wrap it up with the most important points for your exams.
Okay, so before we jump into the sections themselves, let's first get a grip on the basic principle here. We're calling it the judicial shield. What's the core philosophy behind giving this kind of protection in the first place?
You'll find these sections right in Chapter 3 of the BNS, which covers general exceptions. Now, you can think of this entire chapter as a kind of legal shield. It's specifically there to make sure that judges and officers can perform their duties impartially, without constantly worrying about being sued or prosecuted for every single decision they make in good faith.
All right, let's start by looking at the first layer of this shield, Section 15. This one is focused completely on protecting the judge. आज हम डिस्कस करेंगे Section 15 of the Bharatiya Nyaya Sanhita 2023.
Now, take a close look at the wording here. The really key phrases are acting judicially and in good faith. What does this really mean? इसको सिंपल भाषा में समझे तो अगर एक जज नियत से यानी गुड फेथ में कोई काम करता है, ये सोचते हुए कि कानून ने उसको ये पावर दी है, तो वो काम ऑफेंस नहीं माना जाएगा, even if it turns out he was genuinely mistaken about his powers or jurisdiction. इस सेक्शन में 3 इंपॉर्टेंट चीजें हैं. First, the person must be a judge. That's straightforward. Second, he must be acting judicially. इसका मतलब है, he must be acting in his official capacity as a judge. For instance, if a judge is involved in a personal property deal, that's a private act. That's not acting judicially, and this section won't protect him. And third, the power he used must either be given by law, or he must, in good faith, believe that the law gives him that power.
Let's make this crystal clear with a practical example. Suppose a magistrate एक arrest order issue करता है. He genuinely believes, in good faith, that he has the jurisdiction to do so. Later, it's discovered that he technically didn't have that jurisdiction. Well, in this situation, that magistrate is protected under Section 15.
This whole principle isn't just theory. It's backed by the Supreme Court. In the landmark case of Anwar Hussain versus Ajoy Kumar Mukherjee, the court held that this protection is absolutely essential to preserve the independence of our judiciary. It allows judges to make decisions freely and without any external pressure.
Okay, so the judge is protected, right? But what about the officer who actually has to go out and carry out that judge's order? Well, that's where the second layer of this shield comes into play. अब हम डिस्कस करेंगे Section 16 of the Bharatiya Nyaya Sanhita 2023.
So, Section 16 is all about protecting the person who is executing a court order. Again, the key condition is that they have to act in good faith, believing that the court which issued the order had the proper jurisdiction. This basically means that a police officer or any other official is safe when they are simply following a court's command.
So, for this protection to apply, there are 4 crucial conditions that have to be met. First, एक कोर्ट का judgment या order होना जरूरी है. Second, the act must be done in pursuance of that order, यानी उस order को follow करते हुए. Third, that order must still be in force. And fourth, the person carrying it out must be acting in good faith.
Here's a classic example, and this is especially relevant for all our APO aspirants out there. Suppose a police officer arrests someone based on a warrant issued by a court. Now, if that warrant is later declared technically invalid for some reason, that police officer will still get protection under Section 16. Why? Because he acted in good faith while following what he believed to be a valid court order.
Now, we've used this term good faith a few times, and it's absolutely key here. It's not just a casual term for having good intentions. The Supreme Court, in the important case of Mata Jogdobe versus H.C. Bhari, clarified that good faith actually requires due care and attention. मतलब अगर कोई काम लापरवाही से किया गया है, यानी without proper checking, तो वो good faith में नहीं माना जाएगा.
Alright, now that we've looked at both sections individually, let's put them side by side. We'll see how they differ, and importantly, how they connect back to the old law, the Indian Penal Code. Let's break down the core logic and the difference here. You can think of it like this. Section 15 is all about protecting the decision maker, the judge, and the purpose is to safeguard judicial independence. On the other hand, Section 16 is about protecting the enforcer, the officer, and the purpose there is to ensure that court orders are obeyed without fear or hesitation. So, one is about independence, and the other is about obedience to that independent authority. Now, this is something you absolutely must note down for your exams. ये BNS Section 15 पहले IPC का Section 77 हुआ करता था, और Section 16 ये पहले IPC Section 78 था.
The core idea is the same, but you have to remember the new section numbers. It's a very likely question. Okay, let's shift gears and talk about the most practical part for all of you. Why is this topic such a hot favorite for examiners? Why is it so crucial for your exams?
Judiciary prelims और mains दोनों के लिए ये section बहुत important है, especially under the broader topic of general exceptions. For the APO exam, you can expect direct problem-based questions on this. And here's a pro tip for your mains: make sure you quote the case laws we talked about, like Anwar Hussain and Matajok Dobe. It really adds weight to your answers. All right, before we wrap up, let's do a super quick revision. We covered sections 15 and 16 of the BNS 2023. The core concept is all about the protection given for judicial acts and for acts done following court orders, as long as they are done in good faith. And for your exams, please remember this is a must-know topic under general exceptions. For more judiciary-focused legal content just like this to help you succeed, make sure you stay connected with us here at Ganga Education.
आज हम डिस्कस करेंगे सेक्शन 18 of the Bharatiya Nyaya Sanhita 2023. You know, this is a really foundational section from the chapter on general exceptions. Okay, so what's our plan for today? Let's take a look. First, we'll cover the basics of section 18. Then we'll dive into its 6 essential ingredients. After that, we'll look at some practical, real-life examples, discuss some landmark court rulings, and finally, we'll wrap up with the most important part, an exam-focused discussion and a quick revision. So, let's start with the absolute core principle here. Section 18 is all about establishing accident or misfortune as a valid legal defense. And this brings us to a very fundamental question that Section 18 answers for us. Is every accident a crime? Well, the simple answer is no, not at all. Criminal law works on a very simple principle. You get punished for an act only if there's a guilty mind or a bad intention behind it. Now, let's look at the exact wording from the bare act. It says, "Nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge." What does that mean in simple terms? It just means that if an act is purely accidental and there was absolutely no criminal intention behind it, it won't be considered a crime. So, the most crucial point, the key word you need to remember is mens rea, which means a guilty mind. I'm sure you've heard of the legal maxim, actus non facit reum nisi mens sit rea. It's a bit of a mouthful, but it simply means that an act doesn't make a person guilty unless their mind is also guilty. Section 18 is completely based on this golden principle. But, and this is a big but, you can't just claim the defense of Section 18. There are certain conditions that have to be fulfilled. We call them the 6 essential ingredients. And remember, it's mandatory for all 6 to be satisfied together. All right, let's break these 6 ingredients down. First, the act must happen by accident or misfortune. Second, there should be no criminal intention or knowledge. Third, the act you are doing must be lawful in itself. Fourth, you must be doing it in a lawful manner. Fifth, using lawful means. And the most critical one, the 6th ingredient, the act must be done with proper care and caution. If even one of these is missing, the defense fails. It's that simple. The theory is pretty straightforward, right? But the best way to understand it is through practical examples. This will make the concept absolutely crystal clear for you. Now, this slide gives us a perfect contrast. Look at the left side. Let's say a person A is driving carefully, well within the speed limit, and suddenly a child runs onto the road. Here, A took proper care and caution, so they will get the protection of Section 18. Now, look at the right side. What if the same person A is driving at a very high speed through a crowded market and hits someone? Well, it's clear they showed no proper care. In this case, they will get absolutely no benefit from Section 18. Let's move on and see how our courts have interpreted this section over the years. Understanding case laws is so important, especially for your mains answers. A landmark case on this topic is Tunda v. Rex. The facts of this case were quite simple. The accused was shooting at a wild boar, but the bullet accidentally hit a person who was hiding in the nearby bushes, and that person died. The court's decision here really illustrates the point perfectly. The court said that the accused did not take proper care and caution. Before firing a gun in such a place, it was his duty to ensure that no other person was present. Because there was negligence, the defensive accident failed. This very principle was strengthened by the Supreme Court in the case of State of Rajasthan versus Kashiram. The Supreme Court made it crystal clear that to take the defense of Section 18, both the absence of mens rea and the presence of due care are absolutely non-negotiable. Okay, let's get to the most crucial part of this entire discussion, your exam focus and revision. The very first point for your prelims, this new Section 18 of BNS 2023 is basically the new version of the old Section 80 of the Indian Penal Code 1860. You will definitely see direct questions like this in your prelims. Now, take a look at this. This is a potential question for your mains exam. Distinguish between accident and negligence. Let's understand it using this table. An accident is a purely unintended act, while negligence is the result of carelessness. In an accident, proper caution is taken. In negligence, there's a lack of due care. That's why Section 18 is a complete defense, but in a case of negligence, criminal liability can arise. So here's the bottom line. For both judiciary prelims and mains, this section is super important. And you can definitely expect a direct question on this topic in the APO exam as well. So please, do not skip this. All right, let's quickly revise this entire discussion in 3 key points. Point 1. Section 18 makes accident a general exception. Point 2. Its core concept is no crime without a guilty mind, or mens rea. And point 3. It's extremely important for both your prelims and mains exams. That's all for today's explainer. For more judiciary-focused legal content like this, please stay connected with Ganga Education. Thank you. Today's session, we're going to break down a really important section into 5 simple parts so you can absolutely master it for your exams. We'll kick things off with an introduction, then we'll decode its key ingredients, see it in action with a great example, understand why it's so relevant for your exams, and finally, we'll wrap it all up with a quick summary. All right, let's dive right in. So, let's get started with our first section, an introduction to what is famously known as the doctrine of necessity. आज हम डिस्कस करेंगे Section 19 of the Bharatiya Nyaya Sanhita 2023. Now this section is a really critical part of the general exceptions chapter. It basically provides a very important defense in criminal law. ये section doctrine of necessity के principle पर based है. Now, what does that really mean? Simply put, it means that an act which would normally be an offense is not considered an offense if it's done to prevent a much larger harm. You know, it's like the law understands that sometimes you just have to choose the lesser of 2 evils. So the big question is, when does this section actually apply? What are the key ingredients, the conditions that absolutely must be there? Let's break it down. देखिए, इस section को apply करने के लिए ये 5 important ingredients prove करने होंगे. All of them. First, the person knows that the act is likely to cause some harm. Second, there's absolutely no criminal intention to cause that harm. Third, the act is done in good faith. Fourth, the main purpose, the whole reason for the act, is to prevent a greater harm. And finally, the harm being prevented is imminent, meaning it's about to happen, and the action taken is proportional. Yaad rakhiye, all 5 of these conditions have to be met together for the defense of necessity to work. Okay, so theory is one thing, but how does this actually work in the real world? Let's look at a practical example and a landmark case that will make this concept absolutely crystal clear for you. Let's use the classic captain's dilemma to really understand this. Imagine there's a ship captain. He has to steer, but he's faced with a terrible choice. Path 1 means he hits a boat with 30 people on it and their death is almost certain. Path 2 means he hits another boat with only 2 people on board. So what does he do? Well, to save more lives, the captain chooses path 2. In this situation, his act is protected by Section 19. Why? Because it was done in good faith with no criminal intent, all to prevent a much greater harm. Now, let's talk about a landmark case that really sets the boundaries here. R versus Dudley and Stevens. In this case, the court held that the necessity to survive is not a defense for murdering an innocent person. This case really makes you think, doesn't it? Can the need for your own survival ever justify taking an innocent life? The court's answer was a clear and firm no. This illustrates a critical point. The doctrine of necessity isn't a free pass. It has its limits, especially when it comes to the grave act of taking an innocent life. So, understanding the doctrine is one thing, but how does it relate to the old law? And more importantly, why is this topic a high priority one for your upcoming exams? Let's find out. So, you should know that ये section पहले IPC का Section 81 हुआ करता था, but that has now been repealed and replaced by the Bharatiya Nyaya Sanhita 2023. So for your exams, you must now refer to it as Section 19 of the BNS. Let me be very clear about this. For both judiciary prelims and mains, ये section बहुत important है. The concept of necessity, it's a real favorite for examiners, especially when they're framing those tricky problem-based questions.
Absolutely, yes. In the APO exam, you can for sure expect either a direct question or a problem-based question on this topic. So make sure you have a really strong grasp of those 5 key ingredients we talked about, because they are going to be crucial for structuring your answer.
All right, that was a lot of information. Let's do a quick revision of everything we have learned today to really lock it in your memory. So here are the 3 main takeaways. First, we're talking about Section 19 of the Bharatiya Nyaya Sanhita 2023. Second, its core concept is the doctrine of necessity, where causing a smaller harm is justified to prevent a much bigger one. And third, its exam importance is extremely high for both judiciary and APO exams. So please remember these 3 points.
And that's a wrap on our explainer on Section 19. For more judiciary-focused legal content just like this, please stay connected with us here at Ganga Education.
आज हम डिस्कस करने जा रहे हैं सेक्शन 20 और 21 ऑफ द ब्रांड न्यू भारतीय न्याय संहिता 2023। ये सेक्शंस चाइल्ड इम्यूनिटी के कॉन्सेप्ट से डील करते हैं और मैं आपको बता दूं जुडिशरी एग्जाम्स के लिए ये एक्सट्रीमली इंपॉर्टेंट है। सो चलिए इसको डिटेल में समझते हैं एकदम आसान तरीके से।
तो देखिए, हमारा रोड मैप बिल्कुल क्लियर है। सबसे पहले हम डॉली इनकम टैक्स के प्रिंसिपल से शुरुआत करेंगे। उसके बाद सेक्शन 20 और 21 को समझेंगे, उनके डिफरेंसेस और इंपॉर्टेंट केस लॉज देखेंगे, और हाँ, एंड में एग्जाम के लिए एक सुपर क्विक रिवीजन भी करेंगे। लेट्स गेट स्टार्टेड।
ओके, सो सेक्शन 20 और 21 पे जंप करने से पहले हमें उसकी नींव, उसकी फाउंडेशन को समझना होगा, और ये फाउंडेशन है चाइल्ड इम्यूनिटी के कोर प्रिंसिपल। लेट्स सी व्हाट दैट इज।
ये जो टर्म है डॉली इनकैपेक्स, ये एक लैटिन मैक्सिम है। सिंपल भाषा में इसका मतलब है गिल्टी इंटेंट फॉर्म करने में इनकेपेबल। सोचो, लॉ का ये मानना है कि एक छोटा बच्चा उसके अंदर वो मेंस रिया, वो क्रिमिनल इंटेंट हो ही नहीं सकता, और अगर इंटेंशन ही नहीं तो उसके एक्ट को क्राइम कैसे माने? सिंपल, राइट?
चलिए अब आते हैं हमारे पहले प्रोविजन पर, सेक्शन 20 ऑफ द भारतीय न्याय संहिता 2023। ध्यान से सुनिएगा, ये सेक्शन बच्चों को देता है एब्सोल्यूट, पूर्ण सुरक्षा। बिल्कुल साफ साफ लिखा है। सेक्शन 20 कहता है कि 7 साल से कम उम्र के बच्चे ने अगर कुछ किया है तो वो ऑफेंस है ही नहीं, पीरियड। ये एक ब्लैंकेट प्रोटेक्शन है, कोई इफ कोई बट नहीं, सिर्फ और सिर्फ एज मैटर करती है, दैट्स इट। तो ये नंबर 7 है ना, दिस इज द मैजिक नंबर, इट्स एब्सोल्युटली क्रिटिकल। जब तक बच्चा 7 साल से नीचे है, लॉ एक कंक्लूसिव प्रिजम्पशन लेती है। अब इसका क्या मतलब हुआ? इसका सीधा सा मतलब है कि कोर्ट मानकर ही चलेगी कि बच्चा इनोसेंट है, बस। आप इसके खिलाफ कोई भी एविडेंस दे ही नहीं सकते। द मोमेंट इट्स प्रूव्ड कि बच्चा 7 साल से कम का है, केस वहीं का वहीं क्लोज, गेम ओवर। ओके, एग्जाम अलर्ट, ये पॉइंट आपको बिल्कुल याद रखना है। ये सेक्शन जो अब BNS का सेक्शन 20 है, पहले इंडियन पीनल कोड का सेक्शन 82 हुआ करता था। इट्स अ डायरेक्ट रिप्लेसमेंट बाय द BNS 2023। मार्क दिस डाउन।
चलो इसको एक सिंपल एग्जाम्पल से समझते हैं। इमेजिन एक 6 साल का बच्चा है, खेलते खेलते अनजाने में एक शेड में आग लगा देता है। अब देखा जाए तो एक्ट में मिसचीफ के सारे इंग्रेडिएंट्स मौजूद हैं, बट यहां एक कैच है। बच्चे की उम्र कितनी है? 6 साल। तो रिजल्ट क्या होगा? सिंपल, सेक्शन 20 आगे आएगा एक शील्ड की तरह और बच्चे को प्रोटेक्ट करेगा। रिजल्ट? नो ऑफेंस। दैट्स द पावर ऑफ एब्सोल्यूट इम्यूनिटी।
ऑलराइट, सो सेक्शन 20 वाज प्रीटी स्ट्रेट फॉरवर्ड, राइट? अब आते हैं सेक्शन 21 पर, और यहां चीजें थोड़ी सी डिफरेंट हैं। सेक्शन 20 से बिल्कुल अलग। ये इम्यूनिटी एब्सोल्यूट नहीं है, ये कंडीशनल है, मतलब इसमें कुछ शर्तें हैं।
अब इस सेक्शन की लैंग्वेज को ध्यान से देखिए। यह अप्लाई होता है 7 से 12 साल के बच्चों पर, लेकिन यहां एक बट है। यह प्रोटेक्शन उन्हें सिर्फ तभी मिलेगी जब यह प्रूव हो जाए कि उन्होंने सफिशिएंट मैच्योरिटी ऑफ अंडरस्टैंडिंग हासिल नहीं की है। बेसिकली वो अपने एक्ट के नेचर और उसके कॉन्सिक्वेंसेस को समझने के काबिल नहीं थे।
तो इस सेक्शन को अप्लाई करने के लिए समझो एक 3 पॉइंट चेकलिस्ट है। फर्स्ट, एज 7 से 12 साल के बीच, चेक। सेकंड, इंक्वायरी, कोर्ट को बच्चे की मैच्योरिटी एग्जामिन करनी ही पड़ेगी, चेक। और थर्ड, द फाइनल फाइंडिंग, कोर्ट को यह कंक्लूड करना होगा कि हाँ, ये बच्चा अपने एक्ट के नेचर और अंजाम को समझने में नाकाम था, चेक। तीनों कंडीशंस पूरी होंगी तभी प्रोटेक्शन मिलेगी।
और हाँ, अनदर एग्जाम अलर्ट फॉर यू। बिल्कुल सेक्शन 20 की तरह ही ये नया सेक्शन 21 पहले इंडियन पीनल कोड का सेक्शन 83 हुआ करता था। द BNS हैज नाउ रिप्लेस्ड इट। ये कंपैरिजन सेक्शन 20/82 एंड 21/83 एग्जाम्स में पूछा जाता है, सो मेक श्योर यू रिमेंबर दिस।
ओके, इसको समझने का बेस्ट तरीका है एग्जाम्पल्स। तो दो अलग अलग सिनेरियोज देखते हैं। एक तरफ सोचिए एक 9 साल का बच्चा है, दुकान से एक खिलौना उठा लेता है क्योंकि उसे लगता है कि वो फ्री है। उसको चोरी क्या होती है उसकी समझ ही नहीं है। सो यहां उसकी मैच्योरिटी कम है और सेक्शन 21 का प्रोटेक्शन मिल जाएगा। अब दूसरी तरफ देखो, एक 11 साल का बच्चा है, वो पूरी प्लानिंग करता है अपने क्लासमेट को चोट पहुंचाने की और बाद में सबूत भी छुपा देता है। उसका ये एक्ट क्या दिखा रहा है? मैच्योरिटी। वो समझता है कि वो क्या कर रहा है और वो गलत है। इस केस में इसको प्रोटेक्शन नहीं मिलेगा। सी द डिफरेंस? इट्स ऑल अबाउट मैच्योरिटी।
राइट। अब हम इस टॉपिक के सबसे क्रूशियल हिस्से पर आ गए हैं। यहां से एग्जाम्स में आई प्रॉमिस यू क्वेश्चन जरूर आते हैं, सो पे क्लोज अटेंशन।
चलिए इस टेबल को ब्रेक डाउन करते हैं। सबसे पहले एज ग्रुप। सेक्शन 20 सिंपल 7 साल से कम, सेक्शन 21 7 से 12 साल के बीच, इजी। नेक्स्ट इम्यूनिटी। सेक्शन 20 में एज वी नो इम्यूनिटी इज एब्सोल्यूट, नो क्वेश्चंस आस्क्ड, बट सेक्शन 21 में इट्स कंडीशनल। अब आते हैं प्रिजम्पशन पर। सेक्शन 20 का प्रिजम्पशन है इररिब्यूटेबल, यानी इसको कोई चैलेंज नहीं कर सकता, इट्स फाइनल। पर सेक्शन 21 का प्रिजम्पशन रिब्यूटेबल है, मतलब प्रोसिक्यूशन एविडेंस देकर यह प्रूव कर सकता है कि योर ऑनर द चाइल्ड वाज मैच्योर इनफ। और आखिरी पॉइंट, इंक्वायरी। जैसा कि हमने देखा सेक्शन 20 में मैच्योरिटी की कोई इंक्वायरी होती ही नहीं, बट इन सेक्शन 21 बच्चे की मैच्योरिटी की इंक्वायरी करना कंपल्सरी है। बिल्कुल क्लियर, राइट?
Okay, you can't talk about this topic without mentioning this landmark case, Hiralal Malik versus State of Bihar. इस केस में सुप्रीम कोर्ट ने एक बहुत ही इंपॉर्टेंट बात कही। उन्होंने होल्ड किया कि क्रिमिनल रिस्पॉन्सिबिलिटी यानी आपराधिक जिम्मेदारी दो चीज़ों से जुड़ी है। पहला, बच्चे की मेंटल कैपेसिटी और दूसरा, लॉ में दी गई एज। सो बेसिकली दिस केस इज द बैकबोन, इट रीअफर्म्स द एंटायर प्रिंसिपल ऑफ डॉली इनकैपेक्स, अ मस्ट नो केस फॉर योर एग्जाम्स।
ऑलराइट, we've covered a lot. अब टाइम है एक सुपर क्विक रिवीजन का। ये वो पॉइंट्स हैं जो आपको एग्जाम से ठीक पहले अपने माइंड में फ्रेश रखने हैं।
सो व्हाई डिड वी स्पेंड सो मच टाइम ऑन दिस? क्योंकि जुडिशरी प्रीलिम्स हो या मेंस, ये सेक्शंस हमेशा इंपॉर्टेंट होते हैं। डोली इनकैपेक्स पर डायरेक्ट क्वेश्चंस या फिर सेक्शन 20 और 21 के बीच का जो मेन डिफरेंस है ना, वो एपीओ एग्जाम्स में भी एक फेवरेट क्वेश्चन है। सो यू जस्ट कांट स्किप दिस।
तो आखिर में 3 बातें जो आपको बिल्कुल नहीं भूलनी है। 1, हम बात कर रहे हैं सेक्शंस 20 एंड 21 ऑफ द भारतीय न्याय संहिता 2023। 2, इस सब का कोर कॉन्सेप्ट क्या है? डॉली इनकैपेक्स। एंड 3, आपका एग्जाम फोकस कहाँ होना चाहिए? द डिफरेंस बिटवीन एब्सोल्यूट इम्यूनिटी अंडर सेक्शन 20 एंड कंडीशनल इम्यूनिटी अंडर सेक्शन 21। दैट्स योर गोल्डन टिकट। तो ये बिल्कुल क्लियर है, राइट, कि बच्चे की क्रिमिनल लायबिलिटी सिर्फ उसके एक्ट पर नहीं बल्कि उसकी समझ और उसकी मैच्योरिटी पर डिपेंड करती है। नाउ इससे आगे जाकर जुवेनाइल जस्टिस के फ्यूचर पर क्या असर पड़ेगा? Well, that's an important question to think about. For more judiciary-focused legal content, make sure you stay connected with us here at Ganga Education.
Today, we're going to tackle a really fundamental question in criminal law, one that, comes up all the time in exams. All right, let's start with a really interesting question. Just think about it for a second. If a person is in a state of mind where they can't tell right from wrong, and they commit an act, is that act still a crime? Well, Indian criminal law has a very, very specific answer to this, and it's found in one key section. So today, we're going to discuss Section 84 of the Indian Penal Code 1860. Now, this section is a super crucial part of the General Exceptions chapter. What does that mean? Well, it basically lays out situations where an act which would normally be a crime is actually not considered an offense at all. Okay, let's look at what the Bare Act actually says. It tells us that nothing is an offense if the person doing it at that specific moment, because of unsoundness of mind, was incapable of understanding 2 things. First, what the nature of their act was, or second, that what they were doing was either wrong or against the law. In simple terms, this is what we call the defense of insanity. And, the whole reason for this is because the law believes that for a crime to happen, you need both the actus reus, the criminal act, and the mens rea, the guilty mind. In these cases, because of the unsoundness of mind, that guilty mind is just absent. Now, to successfully claim this defense, there are 3 essential ingredients that absolutely have to be proven. So let's break them down one by one, because trust me, for your exams, these points are the most critical part. All right, the first ingredient is unsoundness of mind. So what does this actually mean? It means the accused's ability to think, understand, and reason was so weak, so impaired, that they just couldn't process their actions like a normal person would. And here's the most crucial point to remember. The court looks for legal insanity, which is not necessarily the same thing as medical insanity. This is a huge distinction. Not every medical mental condition will automatically qualify for this defense. Second, and this is extremely important, is the timing. The unsoundness of mind must exist at the time of the act. What the accused's mental state was before the act or after the act, well, that's not really as relevant to the court. Everything, and I mean everything, depends on what the accused's mental state was at that exact, precise moment the act was being committed. And this slide, this really gets to the core test of the entire defense, incapable of knowing. It's broken down into two parts. So either the person couldn't understand the physical nature of their act, for example, they thought they were cutting a loaf of bread when in reality they were harming a person. Or, the second part, they had absolutely no understanding that their act was morally wrong or against the law. And here's the key. You only need to prove one of these two conditions. Just one is enough. Okay, let's make this super clear with a practical exam-style example. Let's say there's a person, A, who suffers from severe schizophrenia, and he attacks his neighbor. Now, at that specific moment of the attack, A is having a delusion. He genuinely believes that his neighbor is a demon who's come to kill him. So in this state, A is completely incapable of knowing that his act is wrong, right? His entire defense will hinge on whether he can prove his mental state at that exact moment of the attack. When it comes to Section 84, the most important landmark case you need to know is Dayabai Chaganbai Thakar versus State of Gujarat from 1964. This is a Supreme Court judgment, and you absolutely must mention this case in your mains answers. It's non-negotiable. In this case, the Supreme Court laid down two incredibly important principles. First, according to Section 105 of the Indian Evidence Act, the responsibility to prove insanity, what we call the burden of proof, is on the accused. And second, the standard of that proof is preponderance of probability. Now, this is different from the prosecution standard, which is beyond a reasonable doubt. Preponderance of probability simply means the accused just has to show that it was more likely than not that they were insane, that the possibility of them being insane was greater than the possibility of them not being insane. That's it. Okay, and now for a very important update for your exams. This provision, which was previously Section 84 of the Indian Penal Code 1860, has been retained in the new law, the Bharatiya Nyaya Sanhita 2023. The core concept is exactly the same. You just need to know that you'll now find this provision in Chapter 3 of the BNS. Listen, for both the judiciary prelims and mains, this section is extremely important. In prelims, you can get a direct question on its ingredients. For mains, expect problem-based questions. And for the APO exam, you can definitely see direct questions on this topic. So please make sure you know the ingredients and the landmark case inside and out. All right, let's do a quick revision. 3 key takeaways for your exam. First, remember the law. Section 84 of the IPC, which is now part of the BNS 2023. Second, understand the core concept. This defense is for a person who, due to an unsound mind, can't understand the nature or the wrongfulness of their act. And third, the most critical exam point. The burden of proof is always, always on the accused. For more judiciary-focused legal content just like this, make sure you stay connected with Ganga Education. We'll keep simplifying these important topics for you. See you in the next one.
Today, we're going to dive into a really crucial topic for your judiciary exams, the defense of intoxication, specifically under the new criminal laws.
So here's our plan for today. We'll kick things off with an introduction to Section 23, then we'll break down the legal text itself. After that, we'll see it in action with some examples. Compare involuntary and voluntary intoxication, and finally, we'll zero in on exactly what you need to know for your exam. So, let's get right into it.
All right, let's start with the absolute basics of Section 23. You know, this section really answers a big question in criminal law. Can being intoxicated ever be a valid excuse for committing a crime? Let's find out.
आज हम डिस्कस करेंगे Section 23 of the Bharatiya Nyaya Sanhita 2023. Now you'll find this section in Chapter 3, which covers what we call general exceptions. Think of these as special situations where an act, which would normally be considered a crime, is actually excused by the law. It's like a legal shield.
Okay, knowing the theory is one thing, but to really get it, we need to look at the exact words of the law. So let's decode the Bare Act and see what it's all about.
So, the law says that nothing is an offense if the person doing it was so intoxicated that they were incapable of knowing the nature of the act. What does that really mean? Well, it means the intoxication was so severe that it wiped out their guilty mind, their mens rea.
But, and this is the most important part, this defense only works if the intoxication was involuntary. That means the substance was given to them without their knowledge or against their will.
तो इस सेक्शन में 3 important ingredients हैं जो प्रूव करने जरूरी है. First, you have to prove that the accused was actually intoxicated. Second, you have to show that they were so intoxicated they literally didn't know what they were doing or that it was wrong. And third, the real clincher, the intoxicant had to be given to them secretly or forcibly. You've got to prove all 3 for this defense to even have a chance.
Okay, enough with the theory, right? Let's see how this law actually works in the real world. We'll look at a simple example and then a really important court case. So, imagine this. A is at a party, just enjoying himself. But someone, let's call him B, decides to spike A's drink with a very strong intoxicant without A knowing. As a result, A becomes so disoriented that he ends up hitting another person without having any idea what he's doing. In a situation like this, A could definitely use Section 23 as a defense because the intoxication was completely involuntary. Now, let's talk about a landmark case here, Bosdev versus the state of Pepsu. What's interesting is that this case was about voluntary drinking, but the Supreme Court laid down a super important rule. It said that just being drunk is never an excuse. For intoxication to work as a defense, the person has to be so intoxicated that they are completely incapable of forming the intention to commit the crime. This sets a really high standard and shows why the involuntary part of Section 23 is so critical.
This brings us perfectly to a comparison that, let me tell you, is a favorite for mains exam questions: the difference between involuntary and voluntary intoxication.
And just a quick note for those of you familiar with the old laws, ये section पहले IPC section 85 था, जो अब replace हो चुका है. So whenever you think of the old section 85, you now need to think of section 23 of the BNS 2023. It's a direct replacement.
Just look at this table. The difference is night and day. Under Section 23 for involuntary intoxication, you get a complete defense, almost like the insanity defense, as long as you can prove incapacity. But now look at Section 24, which is for voluntary intoxication, and the whole story changes. There's almost no defense at all. In fact, the law will assume you had the same knowledge you would have had if you were sober. Understanding this difference is absolutely key.
All right, let's pull all of this together and focus on what matters most to you. How is this going to show up on your exam?
Listen closely, क्योंकि judiciary prelims और mains दोनों के लिए ये section बहुत important है. In your prelims, you can expect direct questions about those 3 essential ingredients we talked about. For the mains, get ready for a problem-based question or a short note asking you to explain the difference between Section 23 and 24. And if you're preparing for the APO exam, remember, इस topic पर direct questions frequently आते हैं, so you have to know it well.
Okay, time for a rapid-fire revision. 3 things to remember. 1. Section 23 of BNS deals with involuntary intoxication. 2. The core idea is that it's a complete defense, but only if the intoxication was forced and made the person totally incapable of understanding their actions. And 3. This is a high-priority topic for both your prelims and mains exams. Got it?
And that's a wrap on Section 23. It's a fascinating area of law that really tests the concept of a guilty mind. For more judiciary-focused legal content like this, make sure you stay connected with Ganga Education.
Today, we're going to dive deep into Section 25 of the Bharatiya Nyaya Sanhita 2023.
So here's our plan for today. We'll start with the core rule of Section 25. Then we'll decode its key ingredients. After that, we'll look at a real-world example, discuss a landmark case, and then really zero in on the exam angle. And of course, we'll finish with a quick revision to make sure it all sticks.
All right, let's get started. First up, the core rule. What exactly does this legal provision say?
Okay, so this section is built on a famous legal maxim, valenti non fit injuria. You know, it basically means, to a willing person, no injury is done. In really simple terms, this section is saying that if an adult, that's anyone over 18, agrees to suffer some harm, the act causing that harm won't be considered an offense. But, and this is a huge but, there's a major exception. The act must not be intended to cause death or grievous hurt. Plus, the person doing it shouldn't know it's likely to cause that level of harm.
Now, to really master this section for your exams, we need to break it down into its 4 essential conditions. Think of them as the key ingredients. Let's have a look at each one. So here's the deal, and this is absolutely crucial. For Section 25 to even apply, all 4 of these conditions must be satisfied. First, there can be no intention to cause death or grievous hurt. Second, the person doing the act must not know it's likely to have those severe consequences. Third, there must be valid consent from the person who's getting harmed. This can be spoken, written, or even implied by their actions. And fourth, that person has to be an adult, over 18 years old. If even one of these is missing, well, the protection of this section is gone.
Theory is one thing, right? But for your mains exam, applying this knowledge to a practical situation is what's really going to score you marks. So let's make this crystal clear with a very practical, exam-focused example.
Okay, check out the contrast on this slide. It explains everything perfectly. In the first example, you have two adult boxers who agree to a match. Now, during the fight, one gets a broken nose. That's technically a grievous hurt, right? But because the main intention wasn't to cause that specific injury, but to participate in a sport, the act is protected by Section 25. Now look at the second example. Someone performs a super dangerous stunt on their friend, knowing full well it could be fatal. Here, even if the friend said yes, that knowledge that death is likely completely removes the protection of Section 25. That act becomes a very serious offense.
Examples are great, but if you want to write a top-scoring mains answer, you've got to bring in the case law. So let's see how our courts have actually interpreted the limits of consent in these situations.
A key case you need to know is Punai Fatima versus Emperor. In this case, the court made it very clear that consent is not a valid defense when the specific goal, the main intention, is to cause grievous hurt. This judgment is so important because it draws a clear line in the sand. It tells us that consent isn't a free pass to justify any and all harm, especially when serious injury is the intended outcome.
Okay, let's shift gears now and focus on the most critical information from an exam perspective. This is the part you absolutely must remember for your upcoming exams. First things first, you need to know that this section used to be Section 87 of the Indian Penal Code 1860. It has now been replaced by Section 25 of the Bharatiya Nyaya Sanhita 2023. Trust me, this is a very high probability question for your prelims.
Now, for both the judiciary prelims and mains, this section is incredibly important. In prelims, you'll likely see questions about its ingredients. In mains, you could get a short note or even a problem-based question. And for the APO exam, you can definitely expect a direct question on this topic, so make sure you're well prepared.
All right, time for a super quick revision. Let's lock in these concepts in under 30 seconds. Ready?
So let's quickly recap. 1. We're talking about Section 25 of the BNS 2023. 2. The core idea is that an adult's consent can be a defense for harm, but it doesn't apply if death or grievous hurt was intended or known to be a likely result. And 3. For your exams, remember those 4 essential conditions and the Punai Fatima case. That's your golden ticket.
For more judiciary-focused legal content like this, make sure you stay connected with us here at Ganga Education.
Let's talk about a tough situation. A surgeon performs a high-risk but life-saving operation. Unfortunately, the patient doesn't survive. So, is the surgeon a criminal? While the answer lies in one of the most critical general exceptions in our new criminal law. Today, we're going to break down Section 26 of the Bharatiya Nyaya Sanhita 2023. This is an absolutely crucial section, especially for medical professionals, and, it's a favorite topic for examiners.
So here's our plan for today. We'll start with the basics of Section 26, and then we'll dive right into the 4 essential ingredients that make up this defense. We'll use a very practical example, the surgeon's defense, to make it all crystal clear. After that, we'll look at a key Supreme Court ruling, compare this new section with the old IPC, and finally, we'll wrap it all up with a quick revision to lock in the key points for your exams.
आज हम डिस्कस करेंगे Section 26 of the Bharatiya Nyaya Sanhita 2023.
Now, the Bare Act says that nothing is an offense by reason of any harm to any person for whose benefit it is done in good faith and who has given consent. So what does that really mean in simple terms? It means the law protects actions that are meant to be beneficial, like a necessary surgery, even if they carry some risk. But, and this is a big but, it only applies if 3 conditions are met. It was for the person's benefit, it was done in good faith, and the person consented. Okay, so to use this defense successfully, there are 4 essential ingredients. Think of it as a 4-point checklist that must be completed. First, and most importantly, there must be no intention to cause death. Second, the act must be done in good faith, which in legal terms means with due care and attention. Third, the main reason for the act must be for the person's own benefit. And fourth, you need valid consent, which can be either express or implied. All 4 points have to be there. Right, so that's the theory. But let's see how this actually works in the real world, because that's where it gets really interesting. This section is most commonly used in medical cases, so we'll take that classic example of a surgeon performing a very risky operation. So let's picture this. A surgeon needs to perform a very critical surgery. The surgeon knows there is a risk of death, but their intention is not to cause death. It's to save the patient's life. So that's our first ingredient checked off, no intention. The surgery is obviously for the patient's benefit. That's our second check. It's performed with professional care and skill, which means in good faith. That's number 3. And finally, the patient has given their consent for the procedure, and that's the fourth and final check. So even if, tragically, the patient dies, the surgeon is protected under Section 26 because all 4 conditions were met.
This brings us to a really important question. The law protects a doctor who acts in good faith. But where do the courts draw the line between an unfortunate accident and actual criminal negligence? Let's find out what the Supreme Court has to say about this.
For this, we absolutely have to look at the landmark case of Jacob Matthew versus the state of Punjab, a very important Supreme Court judgment from 2005. This case came about after the sad death of a patient, and the court used this opportunity to set down some very clear guidelines on when a medical professional can be prosecuted. In this case, the court held that, and I quote, "Criminal liability of doctors arises only when negligence is gross." This is such a key point. It sets a very high standard. A simple mistake or an error of judgment is not enough to bring criminal charges. The negligence has to be so severe, so reckless, that it shows a complete disregard for the patient's safety. It has to be gross. Now, as you're preparing for your exams, it is vital to connect the new law with the old one. So let's take a look at where this section comes from in the old Indian Penal Code. ये सेक्शन पहले आईपीसी सेक्शन 88 था, जो अब रिप्लेस हो चुका है by the Bharatiya Nyaya Sanhita 2023. Now the basic idea is the same, but you absolutely must remember the new section number, section 26, for your exams. Here's a common point of confusion for students, so let's clear it up. How is section 26 different from section 25? Well, section 25 deals with consent to suffer harm, like in boxing or other contact sports, and it strictly requires the person to be over 18. But section 26, the one we're discussing, is about consenting to an act for one's own benefit. The focus here is on the benefit, not so much the age, which is why it's the perfect section for medical operations. Okay, so you've got the concept now, but let's talk about what really matters, how to turn this knowledge into marks in your exam. Understanding this section isn't just an academic exercise. It's a strategic move for your preparation.
Judiciary prelims और mains दोनों के लिए ये section बहुत important है. In prelims, you might see a direct question on one of the 4 ingredients. For the mains exam, you could get a problem-based question or be asked to differentiate it from section 25. And if you're preparing for the APO exam, definitely expect a scenario-based question involving a doctor and a patient from this topic. It's a very high probability question.
All right, that was a lot to cover. So before we finish, let's just do a quick revision to make sure all the key takeaways are fresh in your mind. So remember these 3 things. First, Section 26 of BNS 2023 is the legal shield for beneficial acts done in good faith with consent. Second, its core concept is that it's the doctor's protection clause, and it needs all 4 ingredients to work. And third, from an exam point of view, it's a hot topic. Make sure you've mastered the Jacob Matthew case and the difference between Section 25 and 26. And that's our detailed explainer on Section 26. Hopefully, you now have a much clearer understanding of this crucial legal defense. It really makes you think, doesn't it? Does this law strike the right balance between protecting dedicated professionals and ensuring patient safety? It's something to consider. For more judiciary-focused legal content, stay connected with Ganga Education. In this session, we're diving into a really important section from the new Bharatiya Nyaya Sanhita 2023. All right, let's get right into it. Today, we're going to discuss Section 27 of the Bharatiya Nyaya Sanhita 2023. So what is this section all about? Well, it provides a really crucial legal protection. In simple terms, it says that an act is not a crime if it's done in good faith to benefit a child or a person of unsound mind, and you have the guardian's consent. This is what we call a general exception in law. The whole idea here is to protect actions that are meant for good, especially when you're dealing with people who can't give consent themselves. Okay, so for this protection to actually work, there are 3 essential conditions or ingredients that you have to remember. Let's break them down. First up, the person. This has to be a child under 12 years old or someone who is legally considered to be of unsound mind. Simple enough, right? Second, the act. The action itself must be performed in good faith and specifically for that person's benefit. And third, and you really need to pay attention to this one, there has to be consent from a lawful guardian. Now, this consent can be express, given clearly in words or writing, or it can be implied based on the guardian's behavior and the situation. But, and this is something you absolutely need to know for your exams, this protection isn't a free pass. It has some very clear limits. Section 27 will not protect you if you intentionally cause death or even just try to cause death. It also doesn't cover voluntarily causing grievous hurt. We're talking about really serious, life-changing injuries here. There is one small exception. If causing that hurt was the only way to prevent death or to cure a very serious disease, and finally, this protection doesn't extend to abetment, which is basically helping or encouraging someone else to commit any of these serious crimes.
Let's put this into a real-world context with an example to make it super clear. Imagine a surgeon. She has to perform a really high-risk but life-saving operation on a 10-year-old child. Now, the surgeon carefully explains all the risks involved, and the child's parents give their full informed consent. The surgeon acts in good faith, with the only goal being to help the child. In a situation like this, even if something unexpected goes wrong, the surgeon hasn't committed any offense. Why? Because she is protected by Section 27.
Now, that term good faith might sound pretty straightforward, right? But in law, words have very specific meanings. The courts have defined this one very carefully. There's a landmark Supreme Court case you have to know, Sri Ram versus State of UP. In this case, the court made it clear that good faith is not just about having an honest intention. It also requires due care and attention. So what does that really mean? It means you didn't just mean well, you also acted responsibly and carefully, not in a negligent way. This difference is a classic exam question, so make sure you've got it down. Now, for those of you who've studied the old criminal laws, it's important to connect the dots. This legal idea isn't brand new. It was earlier found in Section 89 of the Indian Penal Code 1860. That section has now been replaced by Section 27 of the new Bharatiya Nyaya Sanhita 2023. So the address has changed, but the core legal principle is still the same. Okay, so let's talk about the big question. Why is this so important for your exams? Well, this section is a hot topic for both the judiciary prelims and mains. For your prelims, you can expect direct questions about the age limit, under 12, or the need for a guardian's consent. For the mains, you might get a descriptive question where you'll have to explain the whole section, including all those exceptions we just talked about, and, of course, cite the Sri Ram case. And if you're preparing for the APO exam, that specific definition of good faith is a topic that comes up again and again. All right, before we wrap up, let's do a super quick revision to make sure this sticks. 3 key things to remember. Number 1, this section is Section 27 of the BNS. Number 2, the core concept is protection for acts done in good faith for a child under 12 or a person of unsound mind, but only with the guardian's consent. And number 3, our key takeaway, good faith means more than just honesty. It requires due care and attention, thanks to the Sri Ram case. For more judiciary-focused legal content, stay connected with Ganga Education.
Today, we're diving into a really important topic, something you absolutely need to know for your legal studies.
All right, so today we're going to discuss Section 28 of the Bharatiya Nyaya Sanhita 2023. Now, this section is super important because it really lays down the groundwork for what the law considers to be invalid consent. Okay, so let's look at what the law actually says. It states that consent is not real or valid consent if it is given under fear of injury or it is given under misconception of fact. So what does that really mean? Well, to put it simply, if someone agrees to something because they're scared or because they've been told something that isn't true, the law says, nope, that consent doesn't count. It's not valid. So this section has 3 key ingredients, you could say. And if you really want to get a grip on this for your exams, you've got to understand each one. So let's break them down one by one. First up, we have fear of injury. Now, when you hear the word injury, you might immediately think of physical harm, right? But it's really important to remember that in this context, it's much broader than that. We're also talking about threats of social harm, like, say, ruining someone's reputation, or even threats of legal trouble. Okay, next on our list is misconception of fact. This is pretty straightforward. It's when someone's consent is based on something that's just, well, false. But here's the crucial part, and this is a classic exam trap, so listen closely. It has to be a misconception of fact, not a misconception of law.
You know the old saying, ignorance of the law is no excuse, and that applies here. But being wrong about a key fact, that can absolutely make the consent invalid.
And our third ingredient is lack of capacity. So what does this mean? Well, consent is also considered invalid if the person giving it isn't in a state to truly understand what they're agreeing to. This could be because they are of unsound mind, or maybe they're so intoxicated that they just can't grasp the nature and the consequences of their actions.
And moving on, there's a very clear line drawn when it comes to minors. The law is explicit here. The consent of a child under the age of 12 is always considered invalid. This isn't up for debate, it's a strict, non-negotiable rule.
Now, here's something absolutely critical, especially for your mains exam. We're talking about the mens rea, or the state of mind of the accused. See, it's not enough to just show that the consent was given out of fear or based on a lie. The prosecution has to go one step further. They have to prove that the accused person knew, or at least had a good reason to believe, that the consent was being given under those invalidating circumstances.
Okay, so we've gone through the theory, but how does all of this actually play out in a real-life situation? Let's look at a practical example to make these ideas crystal clear. All right, here's a very simple, classic exam-style example for you. Let's say person A tells person B that he's unmarried. Based on this information, B consents to a physical relationship. But here's the catch. A is actually married. In this case, B's consent was clearly given under a misconception of fact. The key fact here, A's marital status. Because that fact was misrepresented, the consent is not considered valid under Section 28. Simple as that.
And you know, this very principle, especially when it involves a promise to marry, has been looked at very closely by the Supreme Court. In fact, they clarified it in a landmark case that you absolutely must know for your exams. The case is Uday versus the state of Karnataka from 2003. And what the Supreme Court said was this. If a promise to marry was false right from the start, meaning the accused never actually intended to marry the person, then any consent for a physical relationship that was given based on that promise is considered to be under a misconception of fact. You see, the key thing the court looks at is the intention of the accused at the very moment the promise was made. So, for those of you who studied the old laws, it's really helpful to connect the dots. This new Section 28 of the Bharatiya Nyaya Sanhita 2023 is essentially the replacement for what used to be Section 90 of the Indian Penal Code 1860. Same concept, new home. Okay, let's talk about why this is so important for your exams. I can't stress this enough. This is a critical topic for both judiciary prelims and mains. You can bet on seeing direct questions on this in your APO exams too. Now, a few things to really focus on. First, make sure you nail the difference between misconception of fact and misconception of law. Second, that knowledge of the accused part we talked about, that's a huge area for mains questions. And finally, always remember, this section is applied all the time, especially in cases related to sexual offenses.
All right, before we wrap up, let's do a super quick revision. So what did we cover? 1, we're talking about Section 28 of the Bharatiya Nyaya Sanhita 2023. 2, what's the core idea? It tells us when consent is invalid because of fear, misconception, or a lack of capacity. And 3, why does it matter? It's a high-yield, super important topic for all your judiciary and APO exams. And that's it for this breakdown. For more judiciary-focused legal content just like this, make sure you stay connected with us here at Ganga Education.
In this explainer, we're going to break down a very important limitation on the defense of consent. That's Section 29 of the Bharatiya Nyaya Sanhita 2023.
Here's what we'll cover. First, we'll look at the core provision of Section 29. Then, we'll break it down into its key concepts, see how it works in practice with examples and case law, compare it to the old law, and finally give you the blueprint for your exams.
All right, let's dive straight into our discussion on Section 29 of the Bharatiya Nyaya Sanhita 2023.
So this section is all about the limits placed on the general exceptions, and it specifically deals with the defense of consent. Let's see what the Bare Act itself has to say.
Okay, what does that actually mean in simple terms? Well, it's telling us that some acts are considered offenses all on their own. They are illegal by their very nature. And for these kinds of acts, consent is simply not a valid legal defense. It doesn't matter if the person involved agreed to it, the act itself remains illegal.
Now, to really get a grip on this, let's break this provision down into its most important parts.
You can really boil this down to two main ideas. First, that there are acts which are inherently illegal. Their very nature is criminal. And because of that, we get to our second point. the whole question of consent becomes completely irrelevant. You just can't consent to something that is fundamentally illegal.
So the term you really need to understand here is offense independent of harm. These are acts that the law just flat out prohibits. Why? Well, it's often because they harm society as a whole, not just one person. Think about counterfeiting money. It's an offense by its very nature, right? Consent doesn't even come into the picture. Another great example is bigamy.
We've covered the theory, so let's get practical. We're going to look at a simple example and a landmarked case that really brings this whole principle to life.
This comparison makes it crystal clear. On one hand, if two adults agree to a boxing match, that's a lawful sport. It's allowed by law, and so consent protects them. But on the other hand, if two people agree that one will kill the other, that is still murder. Consent has absolutely no power to make that act legal because taking a life is an offense independent of any agreement.
Now, let's turn our attention to a really important landmark case, Jan Kaur versus the state of Punjab. The principles laid down here are directly related to Section 29.
In this case, the Supreme Court made a huge declaration. It held that the right to life under Article 21 is so fundamental that you can't waive it. It does not include a right to die. So, what does this mean for us? It means that even if a person consents to being killed, the act of killing them is still a crime. This really shows that some things are just beyond the scope of individual consent.
So, is this a brand new legal concept? Let's take a quick look at where this provision came from before the new criminal laws were introduced.
This provision isn't new at all. It was previously found in Section 91 of the Indian Penal Code 1860. It has now been replaced by Section 29 of the Bharatiya Nyaya Sanhita 2023. The key thing to remember is that the core legal principle is exactly the same, only the section number has changed. This means all the case law decided under the old Section 91 is still very relevant for understanding this new section.
All right, now for what is arguably the most important part for you, the exam perspective. What do you absolutely need to remember about Section 29? First, this section is absolutely crucial for both the judiciary prelims and mains. The core idea is that consent cannot make something legal if the law has completely forbidden it. You have to remember that all the general exceptions related to consent are subject to this overriding limit in Section 29. And for the APO exam, you can definitely expect direct questions on this topic.
So, let's do a very quick revision. We've talked about Section 29 of the Bharatiya Nyaya Sanhita 2023. The core concept: consent is no defense for acts that are inherently illegal. And from an exam point of view, it's crucial for understanding the absolute limits on general exceptions. And I'll leave you with a thought. In an era of changing social norms, where do you think the line should be drawn between a person's individual freedom and those acts that the state calls inherently illegal? It's something to think about. For more judiciary-focused legal content like this, make sure you stay connected with Ganga Education.
Welcome. Today, we're going to deconstruct a critical legal provision for your examinations, Section 30, which corresponds to Section 92 of the Indian Penal Code. As a general exception, a thorough understanding of this section is absolutely essential for your success.
So let's start with a scenario that this section is specifically designed to address. How does the law distinguish between a criminal act and a necessary life-saving intervention that's performed under extreme pressure? Well, Section 30 is the very provision that gives us that crucial clarity.
So how does the law actually draw this line? Well, Section 30 sets up the principle that an act, which might otherwise be an offense, is excused if it's done for a person's benefit, in good faith, and without their consent. Let's now examine the specific legal language.
Now, this section lays out a really powerful exception. The core idea is quite straightforward. If you act in good faith to benefit someone who can't give consent, and there's no time to get consent from a guardian, your act is protected. But for your exam, it's absolutely imperative to know the specific conditions that have to be met.
Think of these as the 4 pillars of the Section 30 defense. For any problem-based question you face, you must apply this checklist. Was the act done in good faith? Was it for the person's benefit? Was it truly impossible to get consent? And, very importantly, was the act itself not explicitly prohibited by law?
Right, now it's crucial to understand that this protection is not absolute. The law establishes very clear boundaries. These are detailed in the provisos to this section, which are extremely important, and often form the basis of some of the more challenging exam questions.
Please pay close attention here. You cannot intentionally cause death and then claim this defense. However, And this is a key distinction. You can perform an act that is likely to cause death, but only if the purpose is to prevent death or grievous hurt. This is a subtle but vital point. The same logic applies to causing hurt.
This really clarifies the purpose of the section. You see, the law is concerned with saving life and preserving health, not with protecting financial or, to use the legal term, pecuniary interests. An unauthorized act to save someone's property or investments, for instance, would not be covered. The benefit must relate to the person's physical well-being.
Okay, now let's move from the abstract rules to how this all applies in practice. The illustrations provided right in the code itself are really the best way to understand the nuances, and they form the basis for many judicial interpretations.
This is the classic textbook example. All 4 of our ingredients are met. It was done in good faith, it was for the patient's benefit, consent was impossible to get, and it's not a prohibited act. The surgeon is protected. Simple as that.
Now this illustration, it really tests that second proviso we talked about. A's act was likely to cause death, yes, but his purpose was to prevent death by the tiger. Since his intention was to benefit Z, and he acted in good faith, he's protected, even though the outcome was tragic.
Here, the key is the child's incapacity to give legally valid consent. The surgeon, acting in good faith for the child's benefit when the guardian is unavailable, is protected. The child's pleas in this emergency context are legally irrelevant because of their incapacity.
This is a very powerful example that demonstrates the doctrine of necessity in action. The choice is between certain death in the fire and a chance of survival from the fall. The act, done in good faith for the child's benefit, is completely protected.
Now, we'll turn to case law. As you know, judicial precedents are essential for understanding how courts interpret these provisions. We'll begin with the influential English case of R.V. Bourne.
This case was pivotal because it broadened the interpretation of the word benefit. The court accepted that preventing a grave and permanent injury to a person's mental health could be considered an act done to preserve life.
So, the crucial point from this case is that benefit isn't limited to just preventing immediate physical death. It can encompass preserving a person's overall health, including their mental well-being, when judged by a medical professional acting in good faith.
Next, we have a landmark judgment from the Supreme Court of India, which is extremely important in the context of medical negligence and this particular defense.
The Supreme Court made a very clear distinction here. For criminal liability to be attached to a doctor, the negligence must be gross, not just a simple error of judgment made while acting with due care. This links directly to the concept of good faith in Section 30.
What this case really does is demonstrate the law's intent to protect medical professionals who are making difficult, high-stakes decisions. It ensures they aren't unfairly intimidated by the threat of criminal prosecution for every unfortunate outcome, provided they acted in good faith.
All right, let's now consolidate the key takeaways from our discussion. You should consider this your final revision checklist for Section 30.
Now, a common point of confusion is the distinction between Section 27 and Section 30. This table clarifies it nicely. Section 27 presumes the consent of a guardian is available and given. In contrast, Section 30 operates specifically in emergencies where getting that consent is impossible.
And remember, this section isn't just an isolated rule. It's based on fundamental legal principles. It embodies the doctrine of necessity, it provides a shield for emergency actions, and it hinges entirely on the concept of good faith, which, as you know, has two components: honest intent and reasonable care.
Please pay close attention to this next point. It's critical for your exam. Because this is a general exception, the burden of proof lies with the accused. The person claiming the protection of Section 30 must be the one to present evidence to the court to prove that all its essential ingredients were satisfied.
This chart gives you a final, very clear visual. An act done to save a life in an emergency is protected. An act done for financial gain, like an unauthorized cosmetic procedure, is absolutely not protected. The motive and the nature of the benefit are paramount.
We'll conclude with this problem for you to think about. Apply the 4 essential ingredients we've discussed. Is causing hurt permissible in order to prevent death? Is this act done in good faith? Methodically working through these steps is precisely how you should approach these questions in your examination. We wish you the very best in your preparation.
Today, we're going to tackle a crucial provision in criminal law, Section 31, which deals with communications made in good faith. Now, this is a fundamental concept, especially for professionals who sometimes have to convey very difficult news. Understanding this section is absolutely key for your exams. Let's begin. So to make sure we have a thorough understanding, we'll follow a very clear structure. First, we'll look at the problem this law is trying to solve. Then, we'll decode the section itself. After that, we'll break down its essential components, look at important case law, clarify who has the burden of proof, and finally wrap up by discussing its overall purpose. All right, let's start by looking at the real-world situations where a law like this becomes so important. We're talking about what's often called the professional's dilemma, a situation where just doing your job and being honest could potentially lead to some really harmful consequences. So let me ask you this. Can simply telling the truth be a crime? Think about it. A surgeon has a duty to inform their patient about their condition, even if the prognosis is grim. But what if that patient, upon hearing the news, dies from the shock? Should that surgeon be held criminally responsible? This is the exact high-stakes problem that Section 31 is designed to address. Now, thankfully, the law provides a very specific answer to that question. It offers what we can call a legal shield for professionals who find themselves in this difficult position. So let's decode the exact provision that gives them this protection. I want you to pay very close attention to the wording here. The three key phrases are good faith, any harm, and for the benefit of that person. What the law is saying is that if a communication is made with the right intention and for the person's own good, it doesn't become a crime, no matter what harm might accidentally result from it. And to make this concept crystal clear, the law itself provides this classic illustration. A surgeon tells a patient in good faith that they cannot live. The patient dies from the shock. The law says the surgeon has committed no offense. Why? Because the communication was part of their professional duty, done for the patient's benefit. Okay, now for your exams, this next part is absolutely critical. This legal protection isn't automatic. To successfully use the defense under Section 31, the accused person has to prove 4 distinct conditions. You should think of it as a checklist. And remember, all 4 of these ingredients must be present. First, there has to be a communication. Second, it has to be made in good faith, and we'll define that term legally in just a moment. Third, the purpose of the communication must be for the benefit of the person receiving it. And finally, the harm must have been a direct result of that communication. If even one of these is missing, the defense fails. So we've read the statute, but how does this all work in practice? It's one thing to know the text of the law, it's another to see how our courts actually interpret and apply it. And the most critical concept they look at is the meaning of good faith. Let's be very clear about this. In our everyday language, good faith might just mean being honest, but in law, it's what we call a term of art. It has a very specific legal meaning that requires a much higher standard than just a simple, honest belief. The courts have broken down this standard into 3 core components. For communication to be legally considered as being in good faith, it must, of course, be based on an honest belief. But it must also be made with due care and proper attention. All 3 must exist together. So a statement that's careless, even if it's honest, might not qualify for this protection. And this principle is cemented for us by the Supreme Court. In the landmark case of Shri Ram versus the state of UP, the court was explicit. It held that good faith requires due care and attention. It is not just about an honest belief. This is a crucial point to remember for your answers. The case of Jacob Matthew further solidifies this, especially within the medical context. Here, the Supreme Court affirmed that a doctor, our classic example, is protected from criminal liability when they act with reasonable care and in good faith, even if the outcome turns out to be tragic. So, let's look at some clear exam-focused scenarios to really nail this down. A doctor truthfully informing a patient of a terminal illness? That's protected. A lawyer advising a client that their case is weak and they should settle? That's also protected. But on the other side, spreading false medical information or communicating something just to insult or defame someone, well, that clearly lacks good faith and gets no protection under Section 31. Okay, so we've established what the defense is. But in a courtroom, who is actually responsible for proving that all these conditions were met? This brings us to a very important procedural point, the burden of proof. The onus or the burden is on the accused. If our surgeon is charged, it is on him to prove to the court that his communication was in fact made in good faith and for the patient's benefit. This principle comes directly from Section 105 of the Evidence Act, which says that the burden of proving that a case falls within a general exception always rests on the accused person. All right, let's now bring all of this together and understand the fundamental reason this law exists. What's the purpose behind Section 31? Well, it's all about striking a very important balance. Ultimately, Section 31 is a carefully constructed legal tool. It balances a professional's freedom and, indeed, their duty to communicate honestly with the welfare of the person receiving the information, all while protecting that professional from being unfairly punished for just doing their job. It ensures that sincere advice isn't silenced by the fear of prosecution. And to conclude, I'll leave you with a thought to ponder. We've talked a lot about doctors and lawyers, but in our modern world of instant messaging, social media, and constant information sharing, how does this vital legal principle of acting with due care and attention apply to our everyday communications? That is certainly something to think about. Here's our game plan for today. We'll start with the basic concept, then we'll really get into the nuts and bolts of Section 32 itself. After that, we'll lay out the 5 essential conditions you have to know, see how they play out with some landmark cases, and then we'll clear up a common point of confusion, the difference between compulsion and private defense. Finally, we'll wrap it all up with the key exam takeaways. All right, let's dive right in. At its heart, Section 32 is all about a fundamental conflict, isn't it? It's our natural, hardwired instinct to save ourselves versus what the law demands of us. It really makes you ask the question, what does the law expect from a person when following the law means certain instant death? Well, this section is the law's attempt to answer that very question. So, the legal term for this is duress, or compulsion by threat. Essentially, it's a defense a person can raise when they've been forced to commit a crime. But, and this is key, it's not just any threat. It has to be a threat that makes them reasonably believe they will be killed right then and there if they don't comply. This quote really gets to the core philosophy behind the defense. You see, the law tries to be practical. It understands that when you're staring death in the face, that instinct for self-preservation is an incredibly powerful force. The law simply does not demand that a person become a martyr. Okay, so now for the most important part, the actual text of the law. To really master this for your exams, you have to know the provision inside and out. Let's break it down. Let's analyze this language very carefully. The section opens up with a huge statement. Nothing is an offense. But almost immediately, it carves out 2 major exceptions. This defense is completely unavailable for murder and for those offenses against the state that are punishable by death. And look at the standard for the threat itself. It must cause a reasonable fear of instant death, not future harm, but instant. Now, let's look at the qualifications attached to this section. These are absolutely crucial for applying it correctly. The proviso lays down a big rule. You can't claim duress if you voluntarily put yourself in that risky situation in the first place. Explanation 1 gives us a perfect example. You join a gang of dacoits, you can't later claim you were forced to commit a crime. You knew what you were getting into. On the other hand, explanation 2 shows the opposite. A blacksmith who is kidnapped and forced at gunpoint to break open a door, well, he can claim this defense. So, to make this really practical for you, especially for those tricky problem-based questions in exams, let's distill this all down into a simple 5-point checklist. If even one of these conditions isn't met, the defense is going to fail. Let's run through this checklist together. First, there must be compulsion from an outside threat. Second, that threat has to be of instant death, nothing less. Future harm won't cut it. Third, the crime committed has to be a direct result of that threat. Fourth, and this is a big one, no voluntary exposure. The person can't have walked into the situation willingly. And fifth, always remember the 2 big exceptions. The act cannot be murder or a capital offense against the state. You know, theory is one thing, but law really comes alive when you see how it's applied by the courts. So let's take a look at a couple of landmark cases to see these principles in action. We have to start with the classic case, the foundational case of Dudley and Stevens. It's a very grim story, but it establishes an incredibly important legal line that we cannot cross. So in this case, you had shipwrecked sailors who were dying of starvation. To survive, they killed the weakest person on board, a young cabin boy. The court had to decide if this extreme necessity could be a defense for murder, and the answer was a firm no. The court established that you cannot choose to take an innocent life just to save your own. This principle aligns perfectly with that explicit exception for murder we just saw in Section 32.
Now let's jump forward to a more modern case, R versus Hassan. This one deals directly with that idea of voluntary association with criminals.
Here, the House of Lords was absolutely clear. If a person voluntarily joins or associates with a criminal group known for violence, they can't turn around and claim duress if they are later threatened by that same group. The logic is, you should have foreseen the risk of being coerced. This principle is exactly what is captured in Explanation 1 of our Section 32.
All right, time for a quick test. This is exactly the kind of problem you might get in an exam. A blacksmith is kidnapped by dacoits. They put a gun to his head and tell him to break open a door or they'll shoot him right there. Can he claim the defense of duress? Think about it.
Yes, of course. The defense is available. Let's run our checklist. Was the threat of instant death? Yes. Was he there voluntarily? No, he was forcibly seized. This is a textbook application of Explanation 2. Okay, now for scenario number 2. This time, a person willingly joins a criminal gang. During a robbery, the leader threatens to shoot him if he doesn't help assault a security guard. Can he claim duress? The answer here is a clear no. The defense is not available. Why? Because he voluntarily placed himself in a situation where being forced to commit a crime was a foreseeable, probable consequence. This falls right under Explanation 1 and echoes that principle from R. v. Hassan.
All right, let's move on to a very high-yield topic for any competitive exam, distinguishing Section 32 duress from the right of private defense. Examiners absolutely love to test your clarity on this, so let's make sure we have it down cold. Let's break down the key differences point by point. First, think about the nature of the act. Under compulsion, you are a passive instrument. You're being unwillingly used. But private defense is an active right you are exercising. Second, where is the threat coming from? In duress, the threat is from a third person, forcing you to harm an innocent party. In private defense, you act directly against your attacker. Third, the legal standard. Duress demands a very high bar, a threat of instant death. Private defense requires the use of proportionate force. And finally, this is the most critical one, is murder allowed? Under duress, the answer is never. In private defense, however, causing death can be justified in certain situations.
We've covered a lot of ground today, so let's consolidate everything into the most important points that you need to lock in for your exams.
Okay, let's recap the key takeaways. First, always remember that Section 32 is a very limited defense. It's a concession to our instinct for self-preservation, not a free pass. Second, the threat has to be of instant death. Nothing less will do. Third, the defense is completely lost if there was voluntariness. If you put yourself in that situation, you can't claim duress. And fourth, remember the absolute bar. This defense can never be used to justify murder or capital offenses against the state. If there is just one sentence you take away from this entire explainer, let it be this one, because it perfectly sums up the entire philosophy of Section 32. Compulsion excuses crime, but never murder. Thank you for your attention.
So what happens when you're forced to commit a crime? I mean, really forced, against your will. Well, today we're diving deep into that very question by breaking down the law of duress, specifically focusing on Section 32 of the new Bharatiya Nyaya Sanhita 2023. Just imagine this for a second. There's a gun to your head. Someone is ordering you to break the law. Your life is literally on the line. In that moment, in the eyes of the court, are you a criminal? This is exactly the kind of high-stakes dilemma our legal system has to wrestle with.
And yet, the law does have an answer for this. It's a specific legal defense known as duress, or as the new code frames it, compulsion by threats. This whole concept is laid out for us in Section 32 of the BNS, and that's what we're going to unpack today. Here's our game plan. First, we'll look at the basic idea behind it all. Then we'll decode the actual text of the law. After that, we'll tackle the huge exception for murder, see how this all works in practice with some real scenarios, and finally, wrap up with the legal balance the law is trying to strike.
All right, let's start with the core principle, a threat which leads to an act. At its very heart, Section 32 is a legal tug-of-war. On one side, you have our powerful, primal instinct for self-preservation. The law gets it, it doesn't expect you to be a martyr. But on the other side, it has a duty to protect society from really serious crimes. And that's the fundamental conflict this law tries to solve.
Okay, so how does the law actually put this into words? Let's get into the nitty-gritty and decode the letter of the law itself.
Now, the precise language here is absolutely critical. Notice those key phrases, compelled by threats, and the really crucial standard of instant death. This isn't about just any old threat. We're talking about the most severe and immediate kind imaginable. So to unpack that dense legal jargon, we can break it down into these 5 essential ingredients. For this defense to even have a chance, every single one of these conditions has to be met. There must be a threat,
That threat has to be of instant death, the crime has to be a direct result of it, you can't have voluntarily put yourself in that spot, and, of course, those major exceptions have to be considered. You know, this whole idea isn't new. It's actually built on some ancient legal principles. The first one basically means an act isn't a crime if your mind isn't guilty. And if you're under duress, your free will is gone, so there's no guilty mind. The second one suggests that when it's a matter of life or death, sheer necessity can sometimes override the law. And now we get to the big one, the most critical limitation in this entire section. Where does the law draw a hard, immovable line? It's with the crime of murder. To really understand why, we have to talk about a famous and honestly pretty grim case from way back in 1884. 4 sailors were shipwrecked, stuck in a tiny boat, thousands of miles from land with no food or water. To survive, 2 of them made a terrible choice. They killed and ate the weakest person on board, a young cabin boy. Their argument? It was a necessity. They had to do it to live. But the court completely disagreed. The ruling they handed down was historic, an absolute necessity is not a defense to murder. They said that even the most extreme desperation doesn't give you the right to take an innocent life. You simply cannot choose to sacrifice one person to save another. And this is the key takeaway, everyone. That principle, from an English case over a century ago, is the direct philosophical ancestor of the murder exception we see in Section 32 of the BNS today. The law is crystal clear. The sanctity of an innocent life cannot be compromised even under the threat of your own death. Okay, enough theory, enough history. Let's move from the abstract and see how these principles actually play out in some concrete, practical scenarios. Let's look at these 2 examples. Classic exam stuff. In the first one, a blacksmith, an innocent person, is forced at gunpoint to break down a door. The threat is of instant death, and he didn't put himself in that situation. The defense? Absolutely available. But in the second scenario, a person voluntarily joins a criminal gang. By doing that, they've basically given up the right to later claim they were forced. The defense is not available. Well, let's hammer this home with 2 more quick ones. What if you're forced to kill someone, even at gunpoint? Nope. The murder exception kicks in. No defense. And what if the threat isn't of instant death, but something less, like, we'll beat you up? The law is clear. That doesn't meet the incredibly high standard. No defense there either. Now, here's a distinction that can trip a lot of people up, especially in exams. Comparing compulsion with private defense. Under compulsion, you're basically a passive victim of a threat. But in private defense, you are actively defending yourself from an attacker. And check out that last row. It's the real kicker. While compulsion is never a defense to murder, private defense sometimes can be. That's a huge difference. All right, let's bring it all together. What are the absolute must-know takeaways from our look at Section 32? If you only remember one thing from this entire explainer, please make it this. For any exam, for any legal discussion, this is your golden rule. Compulsion excuses crime, but never murder. That single sentence perfectly sums up both the power and the limits of this law. And this brings us right back to where we started. When you step back, you see that Section 32 is really a masterful balancing act. It's a humane law that protects our fundamental instinct to survive, but it draws a very firm line in the sand to uphold society's absolute need to prevent the most terrible crimes, especially murder. And I want to leave you with one final thought. This law was written for a world of physical threats, guns and knives. But what about today? In an age of digital blackmail, deepfakes, and intense psychological pressure, does the standard of instant death still cover the full range of threats that can completely destroy a person's free will? It's a huge question, and it's one the law is definitely going to have to grapple with as we move forward.
Welcome. Today, we're diving into a really key principle of criminal law, the idea of slight harm, as laid out in Section 33 of the Bharatiya Nyaya Sanhita. Now, if you're preparing for your Judiciary, APP, or even your LLB exams, this is a topic you absolutely cannot skip. So let's get straight to it.
Okay, so the foundation for this entire topic comes down to one really important Latin maxim: de minimis non curat lex. What does that mean? Well, it literally translates to the law does not concern itself with trifles. It's this core idea that our legal system isn't there to deal with every little tiny problem that really forms the heart and soul of Section 33.
So you have to ask, right? In a world full of very serious crimes, what does the law do about all those minor annoyances and petty acts that happen every day? Well, the criminal justice system is designed to tackle substantial wrongs, not get stuck dealing with every single minor complaint. And that's exactly where Section 33 steps in. Think of it as a really important legal filter.
All right, here's our roadmap for today. We'll cover why the law ignores trivial acts, we'll understand Section 33 of the BNS, break down its 4 essential ingredients, see how courts apply the law, and wrap up with the key exam takeaways.
Okay, let's jump into our first section, Law Ignores Trivial Acts. So what's the purpose behind this principle? Why is it actually so important for our justice system to, just ignore certain things?
Well, the logic here is actually pretty straightforward. First and foremost, the goal is to make sure criminal law is used to punish substantial wrongs, not every little thing. It also helps prevent our courts from getting clogged up with unnecessary lawsuits. It stops people from using the law to harass others over trivial complaints. And ultimately, it keeps the courts from getting so overburdened with petty stuff that they can't focus on the really serious cases.
All right, moving on. Let's look at how this principle is actually captured in the statute books. We're focusing on Section 33 of the BNS. And for those of you who studied the old code, you'll recognize this. It's the direct counterpart to the old Section 95 of the IPC.
So here's the actual wording from the Sanhita. It says that nothing is an offense if the harm is so slight that a person of ordinary sense and temper would not complain. Now, I want you to really lock in on that phrase, a person of ordinary sense and temper. This is the absolute key. The law doesn't care how a particularly sensitive person might feel. It's an objective test. The court has to ask, would a reasonable average person complain about this? That's the standard.
Okay, now for the most important part for your exams. To really nail a question on this, whether it's a problem-based question or for your mains paper, you have to know the 4 essential ingredients of this section. So pay close attention because this is the real core of the doctrine.
So let's break it down. First, some harm must actually exist, bodily, mental, or to property. Second, that harm has to be slight, trivial really. Third, we apply that objective standard we just talked about. Would a person of ordinary sense and temper complain? And now look at this 4th point, because this is where a lot of students get tripped up. Intent is irrelevant. That's right. The law says even if the harm was intended, if the result is so trivial, it's still not an offense. This is such a critical detail to remember.
So we have the theory, but how does this play out in the real world? Let's look at how the courts have actually applied this law. We'll go through some judicial interpretation and precedent, which is, as you know, absolutely vital for your answers.
And the one case you absolutely must know for this topic is Vita Menezes versus Yusuf Khan. Now, this was decided under the old Section 95 of the IPC, but don't worry, its legal principles are completely applicable to our new Section 33 of the BNS.
Let's look at the key points here. The facts were simple. The accused threw a file, it hit the complainant, and caused a minor scratch. So what did the court do? It applied the reasonable person test. It asked, would a person with ordinary sense and temper actually file a criminal complaint over a tiny scratch like this? And the Supreme Court's ruling was, no. The harm was trivial, and so the defense was allowed. It's a perfect example of the objective standard in action.
This comparison here really helps make it clear. Think about it. A light, joking push between friends, with no real injury. That's slight harm. But what about a slap in public? Even if it doesn't leave a mark, the insult and the public humiliation are very, very serious. That is not slight harm. Why? Because any person of ordinary sense and temper would absolutely complain about being humiliated like that. So you see, it's not just about the physical injury. The context, the circumstances, the social setting, it all matters. Okay, this is another really important point, especially for your objective questions, because it's easy to confuse Section 33 with the right of private defense. Let's be very clear, Section 33 is a defense you use after a trivial harm has already happened. On the other hand, private defense is a justification you use to prevent harm from happening in the first place. They are completely different legal concepts that apply in totally different situations.
All right, let's bring it all together with a quick revision. These are the key exam takeaways, the absolute must-know points about Section 33 that you need to have at your fingertips.
So, let's recap the essentials. First, the whole defense is based on that maxim, de minimis non curat lax. Second, the harm caused has to be genuinely trivial. Third, the courts use the ordinary person test, not a hypersensitive one. Fourth, and this is for the accused to prove, the burden of proof is on them, based on a preponderance of probability. And finally, don't forget, even intentional minor harm can be excused. If you can remember these key points,
You'll be in great shape for any question on this topic.
And I want to leave you with this thought. Criminal law punishes real wrongs, not childish irritations. This quote just perfectly sums up the entire spirit and purpose of Section 33. The law is meant to be a shield against serious injustice, not a sword to be used for every petty disagreement. And that concludes our deep dive into the law on slight harm.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.